Okay, so thank you. And first of all, I just wanted to note some acknowledgements in terms of where I'm coming from. I'm coming not only from Australia, where we never stand still, but also from working on a lot of these things with a lot of other people. That's a very sort of incomplete list up there, but it's very important to acknowledge that a lot of what I'm talking about today arises out of a kind of long-standing joint collaboration with people in law, with people in psychology, particularly in this context with Christy and Richard and David, but others across Australia and also in Canada. So that's just sort of one, that's the first thing. The second is to very much thank the organisers of this workshop, but particularly David, for encouraging me to come and to participate and to learn lots of things. And I'm still processing a lot of what those things are. What I wanted to talk about today, in fact, in many respects, I think it bounces really nicely off what Christian was saying, and it bounces, I think, off what Ulrika was talking about this morning, though I haven't actually processed exactly how to think about what she was telling us as much, because I think it was such a rich way of thinking around the different types of decisions that people are making. So I'm going to make a little, first of all, I want to start, and I'm going to probably repeat a little bit of what actually Christian was talking about, which is about the legal decision-making context. And part of the reason why I sort of listed these is I was thinking, as I've been listening to the talks, about the different ways in which the models that are being proposed, whether they are the story model or the narrative model or the Bayesian network model kind of fit in terms of what type of decision making they're trying to support. And I think when you're thinking around the legal trial, you want to be thinking, obviously, very carefully around those sorts of questions, is whose decision am I trying to support? But also, what are the other kinds of constraints to those different decision makers at different points? So some of the points that I think we need to kind of be bearing in mind are things like the ones that Christian said. There are rules constraining this decision-making process that are not necessarily evenly distributed. The adversarial model that we were talking about and that was being sort of referred to is a really important sort of central way of thinking about the common law trial as opposed to an inquisitorial trial. But it's got this accusatorial overlay. It's the accusatorial overlay in a sense that Bill's talking about and Kristen's talking about, which is the sense of we've got other values sort of embedded in that process, which means certain people have to do different things at certain stages. The prosecution has to disclose in a way that the defence, while they have those obligations in Australia at least, it don't have to disclose in the same way. The prosecution has an obligation to call all material witnesses, which is kind of the interesting way about thinking around your investment in your case. Those sorts of accusatorial values that are expressed in things like the presumption of innocence, the right to silence and so forth, need to be thought about, I think, in terms of thinking around the sorts of decisions that people are making. I think this is one of the other things to think about. Legal participants, and I mean in this context kind of lawyers and judges, are often quite ambivalent about their own model. So they are simultaneously invested in the idea that the trial is a good way of resolving a factual dispute. They're invested in the associated trial safeguards, like cross-examination, like warnings and so forth. But they're also sceptical of the capacity of the lay fact finder to deal with certain information. And again, I mean, I think picking on Christian's example there of the constraint around prior convictions, we, as a sort of legal decision maker, constrain the jury from having access to that because we fear that they will reason with that information in an improper way. They will be influenced emotionally by that information in an improper way. And so we are cautious about the way in which we give that to a lay fact finder, and we may be less cautious about the way we give it to a different kind of fact finder, particularly if I am a judge and I'm doing both things at once. And so the rules of evidence, again, they structure the trial, and they often express this kind of ambivalence, so sort of a commitment in the fact that the trial can work, but we also want to kind of constrain what the trial gets access to or what the fact finder gets access to. We might be expressing those kind of fair trial beliefs or those fair trial kind of principles in some of those rules. We might be expressing our perception of risk within some of those rules. So bad character evidence would be one. The rule restricting hearsay evidence would be another. We're thinking about the risks associated with admitting this particular type of evidence, and we're trying to manage those risks. Rules sometimes also express policy goals that have nothing to do with reliability of the evidence. And I think that's also kind of interesting to think about. Rules that constrain, for example, illegally or improperly obtained evidence might not necessarily be directed towards evidence we fear is unreliable. We might be trying to bring some other outcome into effect. We don't want police to coerce confessions. We don't want police to illegally wiretap. It might still gain us useful information. We don't want police to interview suspects without warning them. But they don't necessarily bear on the reliability of that evidence. Some of the rules, and I'll be talking a bit about those, have incorporated what we might consider to be outside knowledge, insights from psychology or from social sciences. So the identification evidence rules do that to some extent. But law has this tendency of incorporating that information then forgetting where it got it from. So it tends to then see itself as generating those rules or generating those cautions in and of itself, and I think that can make it hard sometimes for legal decision makers to understand why they're making decisions in certain ways. And then I think this is probably the final sort of point that it might sound really obvious, but I think it's kind of really important to be bearing in mind. Evidence is going to be evaluated more than once and by different people, and it's going to be evaluated for different purposes. So there's a lot we've talked a lot about, and I will probably still be talking quite a bit about how we want the decision maker to evaluate, for example, identification evidence, and that decision maker is going to be generally a jury. They might sometimes be a judge. But there's also other stages at which that evidence needs to be evaluated, and in particular it needs to be evaluated at the point of admission. And so the decision making that might be made around the evaluation of that evidence at the point of admission might have to involve different kinds of factors than the factors that will be taken into account at the point where I'm trying to decide whether to believe the evidence or not, whether to believe the witness or not, whether to trust the evidence or not. And there's also a kind of final stage in the trial, which is that having heard the evidence, I'm going to be given information often by a judge as to how I should reason with that evidence, and how we inform the lay decision maker in order to help them with that evaluation seems to be also kind of really important to think about. Where does this fit into what we've sort of been talking about here, and also what I'm kind of interested in? So it seems to me that if what I'm talking about in this context in terms of my actual subject matter is to be thinking about identification. We heard this morning some really nice discussion around eyewitness identification. And that's often our kind of paradigm or synodictic sort of way of thinking about identification evidence. The eyewitness, the bystander, they bring that information to court, and we're trying to sort of test its robustness. So I'm interested in that, but I'm also interested in, and we are all interested in, a much broader range of forms of identification than just that involving the eyewitness. And in particular, the sorts of identifications that are generated from the kind of the surveillance assemblage that come to us in terms of CCTV images, that come to us in terms of what you might call ambient or wild images, that come to us in forms of surveillance recordings and so forth. Increasingly, it's this information that decision makers and courts are having to deal with, perhaps even more so than your traditional eyewitness. And I guess we were talking also about this a little bit in a slightly different context, which is that thinking around even traditional eyewitness identification, the differences between sort of the conventional live lineup versus the photo array seems to also be generating some slightly different questions around how people sort of deal with that. So if we're thinking about this much sort of wider range of material that courts are having to sort of deal with when they're thinking about identification, the fact that they have the material in front of them, and we're thinking around sorts of displaced comparisons or displaced watchers or displaced listeners, introduces a whole other kind of range of complicating factors into that process. So in the terminology, I guess, of thinking about what we've been talking about here, maybe it's source credibility. It's that little credibility node that's been attached to all of the witnesses that we've been talking about. And I guess I'm thinking around what types of information we want to populate that credibility node with. And that's going to be different if we're thinking about your traditional eyewitness, then maybe we're thinking about someone who's looking at and comparing photographs with a live person in court. And it's going to be different again if we're thinking about the sorts of situations which are these kind of quite interesting hybrid situations where the court is developing categories of witnesses that are not quite lay and are not quite expert, and it doesn't really quite know how to handle that information. It's responding in some respects to a pragmatic issue. It's got this material and it wants to deal with it. And a lot of the existing structures, the existing rules, don't adequately capture the kinds of processes that these sorts of witnesses are going through or are kind of involved in. And in particular, I guess what we're sort of coming from is that we generally would get a sense that courts need to be far more active. This is the sort of the normative part maybe. Courts need to be far more active in regulating that exclusionary stage rather than necessarily relying on the evaluative stage. And that one of the weaknesses, perhaps particularly in Australia, and I'll really only be mostly talking about Australian cases because that's what I know, in Australia, is that the courts have generally been quite reluctant to think carefully about how to assist the decision maker make rational sort of decisions, evaluate effectively this sort of information. Just by way of, and I will come back to this image again a couple of times, but this is sort of the archetypal case in terms of Australian decision making around images and who can come in and talk about images. This was a case where initially police officers were able to come in and give evidence that they recognised the person from the image. The High Court says no. It made that decision around questions about relevance, about who was in a good position or who was in as good a position as the jury to make that assessment. The result of that case is that this image is, this one in particular in the middle, the initial conviction based on the police evidence is thrown out. But the result of that is a bit is perverse in some ways, which is that the jury in the retrial is then asked to make that assessment, and that that's not necessarily an optimal outcome in terms of managing or dealing with this sort of information. So I want to talk about a few more examples that kind of unpack this idea that we have a much broader range of identifications coming into court. We've got a much broader range, therefore, of ways in which we want to articulate how and what your criteria might be when you're wanting to evaluate that evidence, either at that point of sort of inclusion, exclusion, or at the point where you're trying to give the jury useful information as to how they should assess or kind of deal with that information. I'm going to give one example from the kind of more conventional eyewitness context, and then I'm going to shift into talking a little bit more about some of what we might call the displaced identifications, where we're dealing with these kind of experts, in scare quotes, and what I've kind of designated today, shapeshifters, witnesses that are sort of moving between categories. They're not clearly lay witnesses, they're not clearly experts, and it's unclear from the law's point of view how to deal with them. So just thinking first of all about eyewitness identification, Amanda referred to this report this morning. I pulled a different quote from it, but it's really nice to have that kind of synergy. What I was kind of interested in, I guess, in terms of what was and was not in identifying the culprit as a report, was that it was a pretty sort of conventional sort of overview, rehash I think was your word, of some of the conventional literature. And what I found interesting was that it didn't really engage with anything outside of that conventional paradigm. It didn't engage with the fact that there is this the images are kind of circulating, and other than this one quote, this was pretty much it I found, yep, we know that these things might be happening outside of the formal structures. People might be looking at other forms of images and making identifications from that, but we don't really, and that's going to make things harder, more unreliable, but it doesn't really kind of engage with that. So the case I'm going to talk about is one that does, or did in fact, invoke those problems. And it's a bit of in some respects, it's a kind of less doom and gloom story in relation to the way the courts finally sort of dealt with it. Now, this is a very prominent Australian case, may not have made it at news here, but it was a very sad case. Jill Meagher was abducted and killed in Melbourne. The initial identification of Bailey, or rather the kind of bringing him to the attention of the police as a suspect, it's a little bit unclear what that initially happened. This was some of the CCTV footage that was released at the time, because the figure you can just see there is a figure that was following Jill Meagher home, and so they were wanting to speak to that person. There's some indication that he was initially brought to the attention of authorities by someone who knew him, but he also had a very extensive history of this, and that was really the kind of the core of the case, was that having brought him into the frame, he very quickly became the main suspect. A really quite robust case was built up against him. He pleaded in relation to the murder of Meagher. So it was perhaps an example of where these kind of what we might call ambient images are circulating, propels the investigation, but it doesn't become evidence in any trial. The subsequent trial was a bit more complicated. So because of his history, it was expected and probably known that there were a number of other women who had been attacked by him in the past, prior to the Jill Meagher case. And once the Jill Meagher case kind of hit the headlines, a number of other women came forward to say he was the person responsible for the attack on me, anything up to 12 years ago, in fact, in particular. And in the context of this particular trial, which is the one in the middle there, the initial trial proceeded on the basis that the woman who made that identification, who said that was the man who assaulted me 12 years ago, she'd made that identification on the basis of seeing a Facebook image. So one of her friends had posted his image onto her feed. She'd said that she looked at it and she instantly knew who it was. She said instantly, that's the guy who attacked me. Subsequently, the police do a sort of a photo board. She picks him out of that photo board. Now, the concern at trial is not unexpected. The concern at trial is that there's some displacements issues going on. It's not disputed that she was attacked. What the defence says is, effectively, we're not going to conceal from you his history. We can't do that. Everyone knows who he is. But we're going to simply make an argument that there was a displacement effect. The trial judge allows an expert to give evidence about that information at a very general level. So the trial judge is concerned, in a sense, about the reliability of the evidence. They're making that evaluation, but their decision is that the best way to deal with that is to put it to the fact finder, but give the fact finder some kind of expert assistance to allow them or to attempt to manage that information. The problem with that, I think in many respects, thinking about how is the jury to actually deal with or handle that information, if you like, in the little credibility node, is that it's expressed at this very high general level. We know that these things can happen, displacements can occur. And I think while it's difficult to exclude evidence from an eyewitness on the basis of those sorts of general factors, the response that the court has there, which is to give some sort of expert assistance, isn't in and of itself a particularly helpful kind of response, or isn't particularly kind of robust as a response. Now, interestingly, this goes on appeal. This is what occurs, and the appeal court makes a very different decision. It basically looks at that evidence and makes a much more robust exclusionary decision. It simply says that given those risks, we cannot assess that the probative value is sufficient to outweigh the prejudicial effect, the risk of unfair prejudice to the defendant. So it's an unusual decision in the Australian context. Exclusion decisions are rare. But it's a nice example, I think, of a robust way in which the appeal court kind of thinks of that. Now that fits with a lot of kind of legal normative thinking. We don't want to, in a sense, we want our trial to be appropriately fair, even if we might actually think it's a very high probability of Bailey's guilt. We still want that trial to operate fairly, and the way that we do that is to ensure that we're not exposing that defendant to the risk of unfairly prejudicial reasoning. It squares with that. It may not square with other values. It may not square in a sense with even with sort of accurate fact-finding. You can contrast that case with other sorts of cases where the courts are dealing with images and seem to be, a far more comfortable with allowing what could be potentially highly fragile or very sort of unreliable assessments to be made. Smith actually is one of them, so that one I showed before, where the courts were willing to allow a jury to make a comparison between an Aboriginal man in the dock and a picture of an Aboriginal man in a photo, unclear CCTV, and to see that as being an acceptable process. He was, in that case, actually acquitted. You could contrast it with some voice cases where the courts have far less available in their arsenal in terms of specific rules. So in Australia, one of the problems with the sort of identification evidence area is we have relatively specific rules dealing with visual identification. We have a preference for live lineups that's embedded in the Evidence Act. We have a number of constraints set around the way in which we conduct those lineups. We have a number of incomplete rules in relation to the way we deal with photo arrays. We have nothing in relation to voice identification. It's just simply at large. Is it relevant? Is it unfairly prejudicial? They're the only two bookends that kind of deal with it. So in cases dealing with voice identification, the courts are far less able to think about the way in which the information that they've incorporated from psychology, from social sciences into the rules relating to visual ID, they tend not to move them across to other areas of identification, and particularly around voice. Jeff can talk much more about the hopelessness of the courts in Australia in relation to voice, I expect. And you can perhaps see that in a case like probably one of Christy and I's favourite cases called Bara, where the court has recordings of someone on the phone speaking a Nigerian tonal language, Igbo, and they have a defendant in court who happens to also speak Igbo, and this kind of the double counting issues there are some really quite underexplored. And he speaks briefly in court in English. And the jury is told, you can make a comparison between the recordings you have heard and the voice of the person you have heard in court, and you can come to a conclusion as to whether you think those two voices come from the same person. That's a permissible thing for you, the jury, to do. The only thing we'll tell you is to be careful. People make mistakes. Be cautious. This can be sometimes unreliable. Now, I think when you compare the response in the Bailey case, where you have a robust decision from the Victorian court there, with something like the Court-Barrow decision, you can see that there's some issues perhaps in the way in which Australian courts at the very least are kind of dealing with this. And it's not to say that the Bailey case is representative of other jurisprudence in that court. So that's kind of thinking a little bit, first of all, about sort of more traditional eyewitness identification, and then some of those ideas around sort of jury comparison. So where we slip from the conventional situation where we're trying to evaluate the accuracy of a witness to situations where the jury is being permitted to do their own assessment of the evidence. And I want to then move into talking a little bit more about another sort of example or another kind of set of cases where we're dealing with displaced watchers making their comparisons between questioned images and reference images. Now, in this context, you want to think about where those images are generally coming from, where they're mostly coming from, particularly in Australia and the UK, are from CCTV. This is images that you probably remember, or at least might be familiar with, in the sense of the kinds of sort of structures built around them. These are all captured from the London riots. It becomes a lot of the questions around what we're comparing with, what types of images we're using in terms of the source images. A lot of it's coming from this kind of material, so out of often very particular contexts. When we're thinking about that sort of process in the court, where someone is giving information to the court about their assessment of those images and who is in them, we're moving into the space of what we would call opinion evidence. Now, you'd be familiar with that in the sense that when we're talking about forensic science evidence, we're talking in that realm of opinion evidence. While I think it's probably relatively clear how those rules map onto the kinds of things that forensic scientists are doing, and the issue is really to do with how robust the application of those rules is to that evidence. In these contexts, when we're dealing with some of these cases, it becomes far less clear what kind of witness we're dealing with. And the courts have made it perhaps even less clear again. In Australia, we have this structure which says can't give evidence and opinion unless you're an expert or you fit within this relatively narrow category of lay opinion, which is that you're giving an opinion that is necessary to understand your perception of a matter or an event. Now, traditionally, that's been confined to ordinary eyewitnesses giving an account and incorporating into that account something like an evaluation of it was a hot day, it was raining, car was going fast, and so forth. So lay opinion in that context was generally considered to be pretty bounded in relation to that. When we're dealing with the comparisons between images or voices, then we're much more clearly in the context of what would have been conceptualized as an expert opinion, because we're not giving our opinion of a matter or event that we've seen or observed. We're doing a task and we're presenting an opinion in relation to that task. So traditionally, we would consider where someone's coming into court and saying, I think I've looked at that photo, I think it's X. It sits along a fact-opinion continuum. The courts do say, look, if it's someone who's very familiar, we'll say it's fact. If they're not familiar, we'll say it's opinion. But it's generally conceptualized in terms of sort of where you're not dealing with familiarity as something relating to an expert's opinion. So one of the kinds of examples that we have in Australia, this is always one of our favourite images as well, that really exposed how inadequate the court's response to the problem posed by these sorts of images was in the case of Sept. In this case, you have an armed robbery, and DNA is located on a hammer that was used in the robbery, and also on a white T-shirt found in the back of the vehicle thought to be the getaway vehicle. That DNA is linked to Sept. He responds by saying, I'm from the Aboriginal community, we have a sharing economy, someone else was using my T-shirt, someone else was using my gloves, innocent transfer, basically. There are other ways we can explain this. So he'd caught expert evidence in that context. In response to that, the Crown calls a body mapper to compare the image of Mr. White T-shirt on his head with reference images of Sept, and that particular expert declares that he could identify 8 points of similarity and no differences. And again, the evaluation from the trial court is to say, well, that's information that can go to the jury. We'll allow a methodological experts to come in and explain to the jury why that might not be an accurate method, but it's for the jury to decide that. It's for the jury to kind of manage that information and evaluate that information. It would be a situation where I think you could say that the trial court at that exclusionary stage failed to actually adequately screen that evidence out. Failed to sort of adequately think about whether it's possible for a lay fact finder to make anything meaningful, draw anything meaningful kind of from that information. Now I think you could compare that with a much more robust list of criteria that you've got in the context of your new English rules here, the 19A rules, which give a series of criteria to assist the trial judge to kind of to think about what is reliability or validity of this kind of information. Something we don't have in Australia. In fact, we very explicitly in Australia do not have a reliability standard for expert evidence. But I think one of the things that sort of takes me back to this idea about how to evaluate the credibility of different witnesses, those rules, the 19A rules, and some of the discussion kind of around them, I think tends to elide a number of important issues. And in particular, one of the problems that it does is that it talks about a list that you can go to, a list of experts that have been previously admitted into trials and kind of draw your experts from that, as if the criteria that are listed for evaluating evidence have themselves been incorporated into those decisions. So it's part of the kind of the circularity where law tends to think it's already made the right decision and then reuses those past decisions to guide future actions. So while I think there are some nice developments in the UK in relation to sort of to things about reliability and validity, there's still some way to go there in terms of thinking about how do you populate that node relating to an expert witness. You shouldn't populate it with have they given evidence before and what are their qualifications necessarily, unless you can link those securely to what's going on and unless you can actually show that they perform the task they claim to be able to perform to a relevant level of either accuracy, but at least better than lay people.
Can I ask a quick question?
Yes, of course.
Is it never used in court that if you have not this picture, but the one before where you see the face sort of?
Yep.
As someone who knows the person
Yep.
will do much, much better.
They will. And in fact, maybe what we'll, because I want to make sure we have some discussion in around this. What I'm going to do is I'm going to stop at this one, I think. I think that's going to be the image I might stop at. Yeah. I was going to talk about super recognizers, which kind of starts to bring in that question. But I'll just talk about this one instead, because it actually raises this sort of question.
Also super recognizers.
Yeah, also super recognizers raise these sorts of issues as well. Yeah, so if we're thinking about unfamiliar face matching, absolutely. So what we know about processing faces is we're very good with familiars and we're really bad with unfamiliars. Like that's the kind of, that's the totally crude, broad brush, what do we know about that? But there's some kind of quirks in that process. So one might be the super recognizers. So the super recognizers seem to have some kind of capacity to acquire familiarity and or match accurately that is out of sort of the normal range. So they don't sort of sit necessarily in that ordinary kind of familiar-unfamiliar continuum, or they sit in a different place there. One of the ways that the courts have kind of tried to think about this is well, I guess several different ways. One is by saying, okay, if you're really familiar with them, it's not an opinion, it's a fact. So I know you really well, I look at the picture and I say, that's my son, then great. Yeah, that's probably reasonably accurate. Now in Smith, which was the one we saw before, they show it to Smith, he says, doesn't look like me. They don't show it to his mother. And that's kind of, that could go either way. You know, it might be that the prosecution, she doesn't want to talk to them, and she can't be compelled to because she's his mother, and she can't be compelled to give evidence against him. It might be the defense doesn't want to do it because they don't want to show it to someone who may, in fact, know him very well. So it's certainly the case that we have cases where what you might call genuine familiars have looked at images and then have been willing to testify as to that fact of recognition.
And they will be much more believed than a...
Yeah, and robustly so in a sense. Like I think you could say that that's a rational piece of evidence in that sense. What's less rational is in this context that happened in this kind of case, which is where, and this is again a kind of a shape-shifting hybrid category, which is where you have a situation which in this case you had, again, a facial mapper. She looked at this image. It wasn't quite that. I mean, it was pretty bad. Maybe not quite as bad as that when you look at it small. She looks at the reference image. She says one and the same unique identifiers, like that. Now, the court says she doesn't have the appropriate expertise to that. So you go, that's good. Okay, court does that. But then it says, but she's looked at the images a lot of times. She's acquired an ad hoc expertise in relation to his appearance. And that enables her to draw those conclusions and provide, perhaps not quite to that level of strength, and provide that information to the jury. Now, that's not an Australian invention. It's actually a New Zealand invention, but you have it too. England, it's very much also part of the sort of the English context as well. This idea that instead of having a kind of expertise that we might associate with a scientific method, or an expertise that you can validate in some way, you create this idea, bouncing off the idea that familiarity makes you better, a particular expertise in the appearance of a particular person. Now, in that context, the court, again, I mean, our structures in Australia just don't accommodate that very easily. It's not clear how, it's not lay opinion, unless you're in Victoria, in which case it is. And it's not expert opinion in a kind of evaluative sense, because what is the specialised knowledge that that person is able to demonstrate? So it's a category that is increasingly being relied on, but that doesn't have any kind of clear formal structure within the rules to deal with it in terms of its reliability or its assessment. So again, if you're thinking about trying to kind of populate those credibility nodes, it's quite tricky, but I think kind of interesting to think around what sorts of issues you would put in there to try and both better inform exclusion decisions, but also perhaps better inform the jury evaluation or the lay evaluation if it's being given to them to do. So I'm going to stop so we can have a little bit more sort of questions. And I've got more pictures.
Yes, there's a really interesting example you gave where I was thinking about the Bayesian head and I thought actually it's quite tricky because when the victim identifies this guy, is it Bailey or?
Bailey, yeah.
And what you really want to know is, would she still have identified him if she didn't know he was a serial offender?
And
you can never know that.
And you can never know that.
So what kind of data could you possibly get to try and help you with that?
Yeah, and that's why I think it's a really, and you can't. I mean, that's one of the really, that's in a sense, it's one of the problems that the eyewitness report kind of alludes to. There's all this stuff circulating in ways that we simply now cannot control. People are going to see images of people in ways that we can't necessarily control. And you can't undo it.
I'm more concerned, not so much with seeing the picture before as knowing he's a serial rapist.
Yeah, okay. So she could have seen the picture just going, oh, there he is.
Yeah, but as soon as it's a picture of a serial rapist,
then you know, and that's...
So you really need to condition on her not knowing.
Her not knowing.
How can you do that in this case? So is there any way experimentally one could fill in that table? Otherwise you're...
Once she's contaminated.
Once she's contaminated, that's it.
No, but that's what I mean. So can we?
Can we somehow? You're saying is, can we still take it to trial?
It just occurred to me that's a really problem.
I mean, I think, and I guess, I think this is
related to the counterfactual causal attribution. Yeah. We need to do a counterfactual. Anyway.
Yeah. Could she pick this image? Or could she Yeah. And I don't know if actually my instinct is that unfortunately it may not be possible, and that's a lost opportunity. Like that, that from her point of view, it's like she saw it, she believed it, she was totally genuine.
Yeah. You can't go back and change.
But the degree of contamination was so great that the court on appeal felt they had to exclude it. Now there is a kind of other sub-story. It's both a sub-stories, which is that in that particular case where the Victorian court does actually do this robust thing of exclusion, which is rare, they're actually doing it as part of another fight they're having with New South Wales over the interpretation of and what is the role of the judge to assess probative value versus prejudicial effect. So partly what they're doing in that case is they're actually trying to preserve the position of the judge to make those evaluative and exclusionary decisions, So it's like collateral damage to a bigger
I'm arguing
crime.
that you might even have probative value. That's what I'm saying.
Yeah.
You can't estimate probative value.
And that's effectively what they say. They say it's so low that there's simply nothing, and we have to let this one go. In New South Wales, the court would say it's not for us to make that assessment. We take it at its highest, which means we take it as believed, and then kind of flow from there. So there's some differences there in terms of how it's been dealt with. Yeah. People want their coffee.
Yeah, perfect timing. Thank you very much, everybody. Thanks for both our speakers.